Good evening, everyone. This is no less than the 17th Hugh Laddie lecture. The collection of lectures is quite amazing. Few have been given by Brits, as it happens. So Chris is the third Brit out of the 17 to give the lecture. Welcome, 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 especially to Sir Laddie. Our book of the first 10 lectures has Hugh Laddie's wonderful lecture about the growth of IP beyond reasonable amounts. I can hear him now talking about what's happened since. Our first lecturer is here, Lenny Hoffman. Not all the others are here. Michael Feisch is here. This year we're very lucky. It's quite hard to be a friend of Robin Jacobs sometimes because he comes and asks you to give lectures. And this has been hanging over Chris for about 1.5 years. But we're going to get the benefit of that hanging over. And the sooner we start with that, the better.
Can you hear me at the back? Can you hear me at the back? Yes. I'm very touched and honoured to have been asked to give the 2025 Hugh Laddie lecture. Hugh Laddie was a giant on the intellectual property stage. One of his greatest attributes, though, was his wonderful sense of humour, which pervaded everything he did, whether as a barrister or as a judge. So this immediately presented me with a serious challenge: what to do for a joke. I presented the problem, as always, to my wife, Ros. Well, she said, tell me what the subject of the lecture is. Harmonisation, I replied. Oh God, she said, all you lot ever talk about is harmonisation and bifurcation. So there's my joke. My topic is harmonisation of patent law. It's a big topic and I can only hope to scratch the surface of it. My message is harmonisation of substantive patent law is difficult to achieve. It's one thing to devise international add-ons to the procedural framework for applying for patents. It's quite another thing to achieve harmonisation of the basic rules of substantive patent law. But it has been done. I'm going to ask how, at least for member states of the EU, a place has been arrived at where there's a common court which applies a unified law of patents for their territories. Why do independent nation states ever decide to harmonise their laws? There's no a priori reason why they should do so. Take an example a long way away from patent law. Limitation periods for bringing a claim in debt. How long is it before a debtor can relax in the knowledge that the creditor has delayed too long to be allowed to claim his money back? Many legal systems prescribe a time limit. One might have thought there was some sense in agreeing on the international plane how long that time limit should be. It would certainly be a lot tidier. Here in England and Wales, the limitation period is 6 years. Across the Channel in France, it's 5 years. In Switzerland, it's 10 years. Quite a lot of countries like Norway and Sweden choose 3 years. The longest one I found is Portugal, where it's 20 years. I said it was 6 years in England and Wales, but needless to say, In Scotland, it's 5 years. Clearly, there would be some advantage in harmonising these periods so that lenders and borrowers are not caught out by thinking that the limitation period was longer or shorter than it actually is. But so far as I'm aware, no one has ever suggested an international treaty or European legislation which achieved that result. What is it, therefore, which motivates a harmonisation of laws between states? On September the 16th, 2011, President Barack Obama signed into United States law the America Invents Act. In the White House press statement issued on that day, the president said, "This much needed reform will speed up the patent process so that innovators and entrepreneurs can turn a new invention into a business as quickly as possible." One of the stated objectives of the AIA, as it's known, was, quote, increasing the ability of American inventors to protect their IP abroad. The new law will harmonise the American patent process with the rest of the world to make it more efficient and predictable and make it easier for entrepreneurs simultaneously to market products in the US and for exporting abroad. This remarkable piece of legislation came at the end of a long legislative road for the United States. Its most significant reform was to move the United States patent system from first to invent to first to file. What does that mean? Every patent system has to set a date at which an applicant's claim to be granted a patent is to be judged. Most systems require that at that date, whenever it is, the invention must be both novel and involve an inventive step. Most systems, but not the United States system before the America Invents Act, define that date as the date on which the applicant files an application for protection for the invention at a patent office. In those systems, it doesn't matter when the invention was actually made. The only thing that matters is when the application for its protection landed at the patent office. That's what we mean by first to file. In the United States, before the AIA, you could have your invention judged at an earlier date, namely the date on which the invention was actually made, one might call it the light bulb moment. That meant that prior art which was published between the date of the invention and the date of filing could be excluded from consideration. As you can imagine, this led to difficult factual inquiries as to when an invention was in fact made. When, if you like, the precise moment was when the light bulb came on in the inventor's head. Although large companies would require their employees to keep and have countersigned invention notebooks to record these light bulb moments, small inventors who made inventions in their garages and potting sheds did not. Where there was a dispute between applicants, something called an interference would be declared, in which the rival claims to have invented first would be examined by a tribunal. These were messy, expensive, factual disputes which did nothing to encourage applications for patents, and all just to establish the date at which the substance of any dispute was to be decided. They called it swearing back. There was another problem with the US law. In a world where most other countries ran a first-to-file system and allowed prior art from any country to be cited against a patent application, a foreign patent application based on a US patent application could run into trouble. The prior publication could be ignored in the US, but could not be ignored in the rest of the world. That prior publication could potentially knock out all the corresponding applications in countries where no swearing back was allowed. In the result, prudent US companies played by the rules for foreign applications. In effect, they endeavored to comply with the first-to-file system wherever they could. Less prudent US companies, confident of their ability to show an earlier invention date, were often tempted to publish their inventions between invention and filing, which could lead to disastrous effects abroad. The report for the House of Representatives Committee summed it up succinctly. One, a patent's filing date is objective and simple to determine, whereas an invention date is often uncertain and when disputed, typically requires corroborating evidence as part of an adjudication. Two, the first to file system would avoid the expense and burden of interference proceedings and eliminate the need for inventors to maintain recording and documentation systems. And three, because many US inventors and companies file for patent protection in foreign countries, they are forced by the United States maintenance of the first to invent system to follow and comply with two different filing systems. So the US voted to go with a radical revamp of its patent system from first to invent to first to file and to harmonize with those countries which had first to file. But there was and is another disparity between the US patent system and the European and some other patent systems. The European system operates on what's called a strict novelty basis. That means that a disclosure of the invention, whether by the applicant herself or by any third party, which occurs before the date of application, is available as prior art against the invention. So if the applicant has launched a product, given a lecture disclosing the invention, or made any other non-confidential disclosure of the invention, those matters can be deployed against the grant of the patent. It's the patent law equivalent of the own goal. The United States and some other countries think that the law should cut inventors some slack when they shoot themselves in the foot. Those countries allow what is called a grace period. In the grace period, disclosures by the applicant of the invention are disregarded and the own goal is disallowed. This has well-recognized advantages and disadvantages. One advantage is that it provides a safety net for accidental disclosures by the applicant. This has proved useful for smaller inventors who may not be able to enforce a strict disclosure policy to ensure that silence is maintained until the patent has been filed. It's also possible to use the grace period proactively for deliberate disclosures as well. A university may wish to allow its scientists to publish their findings without having to wait for the all clear from the patent department. Or a drug company may want to advance the development of its drug in circumstances where the drug's chemical structure will become known from clinical trials. A disadvantage of the grace period is that it extends the period of legal uncertainty as to what can be treated as being in the public domain. Third parties will not know that they can rely on the publication of the invention because of the possibility that a patent may still validly be granted for it, even after it has apparently entered the public domain. There is, of course, a period of uncertainty in any event between application and publication, but the grace period will extend that. The existence of a grace period in the US with none in Europe also gave rise to one of the same problems that I mentioned in relation to the US first to invent system. Suppose the university authorities authorize an academic to disclose an invention at a conference in the US and then apply for patent protection in the US and in Europe, or within the grace period. The grace period will save the US patent from being invalidated by the academic's talk at the conference, but will be available to invalidate the European patent. So a prudent university would not take advantage of the grace period if it had ambitions for European protection. Instead, it would comply with the strict novelty requirements of the European system. One answer would be to harmonize and remove the grace period for the US. This is quite a significant problem. A survey by the EPO showed that between 50 and 65% of US companies surveyed had made use of the grace period in filing their applications. It also showed that nearly 60% of US companies that have disclosure policies had to postpone or cancel publications or disclosures to comply with the European novelty requirement. Why would the arguments in favour of harmonisation succeed for first to file but fail for grace periods? The answer, I would suggest, is that the goal of harmonisation, while attractive in theory for its ability to reduce anomalies, is not a sufficient incentive on its own to change national laws which work in the domestic context. First to invent was abandoned because it was cumbersome, expensive and uncertain, purely within the US context. The argument that it created problems abroad was a valid one, but by then the ball was already rolling. By contrast, the grace period was well established and its advantages in the domestic context were seen to outweigh its disadvantages, so it not be changed despite the harmonisation advantage. This might suggest that to achieve harmonisation, one needs to be able to identify a problem with existing national legislation or some supervening strategic goal which would justify the necessary domestic law change. Let's take a step back and do some categorization, which lawyers generally love to do. One can identify at least 4 types of harmonization, and one can grade them like air travel. Economy class harmonization is where a state decides to change its law to be more like someone else's law. The US changed to first to invent is an example of that. No elaborate international treaty or novel court structure is required to achieve it. Next is premium economy, where 2 or more states agree on the international plane that they will conform their laws to some common standard which they will implement in national law. Many international conventions in the IP field are examples of this. Third, there's business class harmonization. This is where it starts to get a bit more expensive, where in addition to an international instrument setting out the substantive law, one sets up a supranational court which decides questions of interpretation of that agreement. That, in a way, is the model adopted by the EU with its system of references to the Court of Justice of the European Union on questions of interpretation of the EU treaties and legislation. A variant of this is the principle applied by most member states of the European Patent Convention to follow the settled jurisprudence of the Boards of Appeal of the EPO, although that is not something which is required by international agreement, and there's no access to the EPO for a decision in an individual case. Finally, there is first-class harmonization, where a court common to member states decides all issues of fact and law arising in disputes covered by the agreement. It's probably a misnomer to call this harmonization rather than unification, but it is undoubtedly at the top of the tree. All but first class have imperfections. Under the system of references to the CJEU, it's well known that after a delay of many months awaiting the outcome of a reference from the National Court, the parties returned to the National Court, both claiming to have won. There will always remain questions of interpretation, either of treaty language or of court decisions, which will lead to failures to achieve the goal of perfect harmonization. The same is true of the system following the jurisprudence of the EPO. I shall return to this problem of travelling business class or below later. The history of global patent law shows that states have succeeded in concluding many treaties aimed at harmonizing patent laws. These include the Paris Convention for the Protection of Industrial Property, the Treaty for Establishing the World Trade Organization, the Patent Cooperation Treaty, the Agreement on Trade-Related Aspects of Intellectual Property Rights, not to mention the Budapest Treaty on the international recognition of the deposit of microorganisms for the purposes of patent procedure. How have these harmonizing measures been achieved? And what is it that they harmonize? Have they gone as far as harmonizing substantive patent law. Let's start with the Paris Convention. It has three basic principles: the principle of equal treatment, the same treatment granted to a member country's own applicants, the right of priority, and the principle of territoriality. The first principle, equal national treatment, would today be called a non-discrimination provision. If you had a no patents for foreigners policy, it had to stop. This reminds me of Tom Lehrer, a most prophetic US academic who is also a singer and songwriter, and who I've cited in almost every lecture or speech I've ever given. Tom Lehrer wrote a mock Joan Baez-style protest folk song, which has the line, "We hate poverty, war, and injustice, unlike the rest of you squares." It should not be difficult to get states to agree on this basic principle of fairness between inventors, whatever their nationality. I'm not sure that many states did have a discriminatory rule. The second principle, the right of priority, is a requirement to recognize an application for protection in a foreign country for an invention as the filing date in the home country. This was a big advantage to all applicants for patents with international ambitions. Without such an agreement, an application for a patent in one country gave you a right just for that country. If you wanted foreign patents, you'd have to file separate applications in the respective countries at the same time, or risk being prior published, and that was expensive. The Paris Convention enabled a hugely convenient method of accessing international protection. The third principle, territoriality, makes it clear that the convention is not a uniform law of patents, but that each state may grant patents in accordance with its own laws and is not to be affected by the fate of corresponding applications in different countries of the Union. This is a rule about the sovereignty of decision-making about patents. It's quite the opposite of a harmonization provision. So there's nothing in the Paris Convention which indicates a desire to have uniform substantive patent laws, and quite a lot which indicates a desire to the opposite effect. What it did was make improvements to the framework for applying for patents. What about the Patent Cooperation Treaty? The Patent Cooperation Treaty makes it possible to seek patent protection for an invention simultaneously in each of a large number of countries by filing an international patent application. Such an application may be filed by anyone who's a national or resident of a PCT contracting state. It may generally be filed with the National Patent Office of the contracting state of which the applicant is a national or resident, or at the applicant's option with the International Bureau of WIPO in Geneva. So it's just a different way of filing for patent protection. It's an add-on to the individual national filing systems of the contracting states. Its output is an international search report, but not a decision on whether a patent should be granted in any state or region. The result, of course, is not an international patent. The output is whatever patents end up being granted by the national or regional patent offices which have been designated, applying their individual national laws. Article 1.2 of the PCT provides that no provision of the PCT shall be interpreted as diminishing the rights under the Paris Convention of any national or resident of any country party to that convention. As you will recall, one of the basic principles of the Paris Convention is the territoriality of patent protection and the independence of the decision-making of separate nation states. And later it makes it even more explicit that the treaty is only about the form and contents of the application and not about substantive patent law. There are, however, treaties which have brought about directly or indirectly harmonization of the substantive patent laws of different states. Two important ones are the Community Patent Convention and the European Patent Convention. There's a further treaty that's gone further than harmonization in Europe, and which has unified the patent system for Europe so that one patent and one law can apply to the entire territory for which the patent is valid, and disputes of law and fact are determined by one court. That is the Unified Patents Court Agreement, or UPCA. How did we get this far? To understand that, we have to go back a long way in history, back to the end of the Second World War. Senior politicians in the countries of Europe had, by 1945, endured 2 world wars and almost 3 decades of conflict. In that atmosphere, the creation of the Council of Europe in 1949 represented a step in the other direction, away from struggles between individual states and towards a united Europe free from aggression. As Robert Schuman, the French foreign minister, and later, I think, Prime Minister, said on the signature of the Council statute, the Council of Europe is, to be sure, the laboratory in which experiments in European cooperation are conducted until such time as it is transformed into an organic institution of European unity. It was in that atmosphere that the Assembly of the Council of Europe met for the very first time in Strasbourg. At that first meeting, the Assembly accepted a proposal by Senator Henri Longchambon of France that there be a study into the feasibility of a European patents office. In fact, his proposal was not really workable, as all the European Patents Office would have been able to do would be to produce an inventor's certificate to carry off to national patent offices. Longchambon's idea, however, undoubtedly planted the seed of what was to happen over the next 75 years. As the years passed, 2 proposals emerged and were considered by a committee of experts under the auspices of the Council of Europe. For this history, I'm indebted to an excellent article by Christopher Wadlow entitled Strasbourg, the Forgotten Patent Convention. The first proposal was a proposal by the German delegate, Professor Edward Reimer. The second was a proposal by the Dutch delegate, Dr. C.J. de Haan. I'm afraid I couldn't find a photograph of him. The former was the president of the German Patent Office and the latter of the Dutch Patent Office. Reimer felt that the creation of a European Patents Office was too radical and expensive, and it could not be achieved until there was substantial unification of substantive patent law. His proposal for a single infringement and revocation court, which he called a European Court of Justice, long before any such court existed, would only seem to work if that court was applying a unified law. De Haan's proposal was second in time, and he had the opportunity to comment on Reimer's proposal. He agreed with Reimer that the creation of a complete system would be difficult until there was alignment of national patent laws. The difficulties he saw included the fact that British applications were only tested against prior art published in the UK, whereas other countries allowed for prior art published anywhere. So when the case came before the European Court of Justice on a revocation action, was it to apply the national law of the country of grant or some more general law? He also doubted, perhaps prophetically, that the creation of a European Court of Justice with a compulsory jurisdiction in infringement and revocation would be politically acceptable. Having made that criticism, de Haan had to be sure that his own proposal did not suffer from the same vices. So his proposal was for a European Patents Office to grant patents on a system of substantive law which adopted all the most severe restrictions of national laws. So if, for example, Germany did not grant chemical patents, then the new European Patents Office could not do so. Presumably this meant that worldwide novelty would apply, as this was the more restrictive option. By this approach of finding the most restrictive system, he avoided the possibility of a European patent being invalid under the national law of one country. It would in many respects, therefore, be more difficult to obtain a European patent than some national patents, and the European patent would grant less protection than a bundle of national patents. it would sail out of the Patent Office already quite severely holed below the waterline. Despite the differences in the two approaches, one can see that both Reimer and de Haan set as their strategic goal a system of litigating a unitary European patent. They differed on the nature of the institutions required to put this into effect. A European Patent Office or national patent offices, a European Court of Justice or national courts. This strategic goal is what drove the harmonisation which was to come. Neither of the two proposals appeared to gain supremacy in the years which followed. When the Plenary Committee of Experts on Patents met in November 1955, the committee appears to have realised that progress could only be achieved towards the ultimate goal if there was agreement on certain fundamental principles of patent law. We have to thank those responsible for not admitting defeat, just because the goal of a complete system was not going to be realised, but going forward to see what agreement could be reached. They did not let the perfect become the enemy of the good. That led to the Strasbourg Convention of 1963, a remarkable convention which preceded the European Patent Convention by 10 years, and which laid down some of the most basic requirements of a sensible patent system covering novelty, obviousness, and sufficiency of description. You may recognise some of its provisions. Article 4.1, which relates to novelty, appears verbatim in Article 54.1 of the EPC. Article 5, inventive step, is substantially adopted in the EPC with the addition of the reference to a person skilled in the art. The decision to press ahead with the Strasbourg Convention is, with the benefit of the long view, one of the watershed moments of the development of European patent law. These provisions of Strasbourg would involve more than one very substantial change to the law in this country. In particular, it's clear that Article 4 introduced a worldwide novelty requirement, sweeping aside the UK's domestic novelty rule. So patents obtained by spotting somebody else's invention abroad and importing it into the UK could no longer be valid. How did the UK react to these proposals? A patent liaison group was set up under the Board of Trade to consider the legislative changes which would be necessary if the UK were to ratify the Strasbourg Convention. It reported to Parliament in December 1965. The members of the group included Geoffrey Tukey QC, Kenneth Johnson QC, John Whitford QC, Mr. George Cook of Bristow's Cook and Cartmel, the solicitor's firm, and Mr. C.E. Every of the firm of what were then called patent agents, Gill, Jennings and Every, as well as many others. 3 members of the group, Johnston, Whitford and Cook, declined to sign the report. The group noted quite rightly that the laws of the United Kingdom would need to be revised in many respects to give effect to the convention. For example, the rule that a patent would only fail for lack of novelty if it had been published in the UK would have to be changed in favour of worldwide novelty. But they complained at the burden imposed on them of suggesting wording to give effect to the new convention. They said, and I quote, "The task is not the simple one of translating into United Kingdom statute the provisions of the convention. It is a complicated business of amending the existing statute so as to remove the parts which are inconsistent with the convention and insert in their place provisions which conform to the requirements of the convention and are couched in language which fits the general pattern of the statute and is free from ambiguity." As you'll recall, Article 4.1 of the Strasbourg Convention stated an invention shall be considered to be new if it doesn't form part of the state of the art. The group considered that this should be translated as the invention, so far as claimed in any claim of the complete specification, already formed part of the state of the art as it existed before the priority date of the claim. Quite what the additional language achieved is difficult to understand. This notion that it's necessary to alter the language of an international convention so as to give it effect in the UK is seriously open to question. It's been commented upon in a number of cases. The point was put with great tact and subtlety by Professor Sir Robin Jacob in Markham and Zypher Corporation, where he said, before doing so, we begin with any rational way to approach this act, whatever section is under consideration. Parts of it are intended to implement the EPC. In a peculiarly cack-handed way, the draftsman chose to renumber and rewrite some of these, and then say, in effect, that his rewriting doesn't count, that the relevant provision is so framed as to have the same effect as it has in the EPC. No one has ever identified any difference in meaning between a 1977 Act provision and the meaning of a corresponding provision of the EPC, and we don't suppose anyone ever will. The suggestion made by the group was that although they themselves were capable of understanding, presumably from reading the convention and its travail, what the convention meant, this would not be possible for the ordinary jobbing barrister, solicitor, or patent attorney who read the very same words. This is such an obvious fallacy. It involves a degree of arrogance and leads to the sort of confusion pointed out in those cases. There is, however, a bigger point at play here. An agreement between states to harmonise their laws as they are applied by the domestic courts is never going to be quite as effective as an agreement to unify those laws under the direction of a single supranational court. The judges have to interpret the legislator's attempt to enact the harmonised laws set out in the International Convention. In countries such as ours, where there's a system of judicial precedent, once they have done so, their interpretation will apply until some higher court changes it. Whatever the interpretation applied in country A, it may differ from that in country B. How are these differences to be resolved in the absence of a court, such as the CJEU, which exists to clarify the law laid down supranationally? A common but unsatisfactory way to resolve these differences is to say that although there are nuanced differences of interpretation, it is likely that the two different rules applied by the two countries will produce the same answer in the vast majority of cases. My favourite is the idea that the problem and solution approach to obviousness will produce the same answer as that laid down by the Court of Appeal in the windsurfing Pozzoli line of cases. The two approaches involve asking a series of questions before coming to the one that matters: is it obvious? The idea behind that is that these two different approaches are no more than judicial orientation prior to answering the only question which matters, which is the statutory one. I don't find that answer at all convincing, largely for the reasons given by Sir Humphrey when discussing opinion polls about national service in the television series Yes, Prime Minister. The Prime Minister had obtained an opinion poll saying that people were in favour of the restoration of national military service. Sir Humphrey was horrified and told the hapless Bernard Woolley to go and get another opinion poll saying the opposite. How do I do that? Asked Bernard. It all depends on the questions you ask before you ask the critical question, said Sir Humphrey. To get a yes, you would ask, do you think young people today could do with a little more discipline and sense of purpose in their lives? To get a no answer, you ask, do you think it is wrong to force innocent young people to take up arms against their will? The idea that the lead-up questions don't affect the answer is faintly absurd. To return to Strasbourg, 13 countries, including the UK, ratified the treaty or acceded to it. It did not, however, come into force until 1980. In parallel, two further conventions, the EPC and the CPC, were being pursued. Work on the EPC began in 1960 with a working party consisting of representatives from a number of countries. They did not at this stage have available to them the concluded Strasbourg Convention, but they did have the Reimer draft. By 1967, the idea had taken hold that there could be a first convention, the EPC, which would be open to non-EEC countries and which would create a European Patent Office with responsibility for the filing and processing of European patents. Then there would be a second instrument, the CPC, which would be open only to EEC member states and which would create a court common to those member states for the enforcement of a unitary patent. In 1973, 16 nations had signed the EPC. The EPC set up the European Patent Office, would act as a granting authority for so-called European patents, which were actually bundles of national patents. Because it granted a bundle of national patents, the European Patent Office had to apply a substantive law of patents and examine the applications for sufficiency of description, capability of industrial application, novelty, and obviousness. Nothing in the EPC laid down that the individual member states had to align their substantive patent laws to the rules the EPO had applied in granting the patent. But the consequences, if the laws were not aligned, would be very messy indeed. A patent could be refused by the EPO, which would have been held valid by the domestic courts, and a patent could be granted by the EPO in order immediately to be revoked in the domestic courts. It made obvious sense to bring our laws into conformity with the law applied by the EPO. The Convention for the European Patent for the Common Market, also known as the Community Patent Convention, was a product of the European Economic Community. In the version available for ratification from 1975, it envisaged a unitary European patent called the Community Patent. Revocation was to be dealt with by special departments of the European Patent Office. These included revocation divisions and revocation boards hearing appeals. Significantly, a further appeal lay to the Court of Justice of the European Communities, as it was then. It had provisions dealing with the effect of the community patent, which formed the basis of the infringement provisions in our national law. It could be enforced in the national courts. Subject to a limited exception, validity would not have been open to challenge in the national court. The national court could seek preliminary rulings from the Court of Justice on the interpretation of the CPC and certain provisions of the EPC, which were binding on community patents. This version of the CPC never came into force because insufficient countries chose to ratify it. It founded, amongst other reasons, on the language provisions, but I suspect the liberal involvement of the Court of Justice did not help its progress. An attempt to revive it was the agreement relating to community patents, sometimes called the Community Patent Convention 1989. That proceeded by way of an amendment to the Convention of 1975. The recitals indicated that a better method of setting up the system would be if national courts, called community patent courts, but effectively the existing court infrastructure of member states, were able to try both infringement and validity. There could also be a referral to a common appeal court, a court common to the member states, and significantly there was to be no further appeal to the ECJ. Despite the effective elimination of a role for the ECJ, this version of the CPC also failed to come into effect. That meant that the goal of a single court with the ability to decide validity and infringement issues for all the member states was yet to be realized. That is not to say, however, that these conventions had no harmonizing influence. The provisions about infringement, which were present from 1975, were the model for the subsequent national legislation, including the Patents Act 1977. A memorandum signed by all parties to the Community Patent Convention upon its signature provided that insofar as they had not already done so, member states were to legislate so as to eliminate as far as possible the differences between national patent law and the common system for the law of patents resulting from the convention. So when enacting the Patents Act 1977, the draftsmen told us that various provisions had been so framed as to have, as nearly as practicable, the same effects in the United Kingdom as the corresponding provisions of the European Patent Convention, the Community Patent Convention, and the Patent Cooperation Treaty have in the territories to which those conventions apply. Those words, of course, do not guarantee that English judges, when applying the provisions of the Patents Act 1977, are going to arrive at the same interpretation of the conventions as their counterparts in, say, Germany, France, or the Netherlands. They are merely a statement of the draftsperson's intention to implement the terms of the conventions. What happens when you get disagreement between decision-making bodies under these conventions? The answer is that courts do try to reach a harmonised approach, but they're not always prepared to do so when it involves departing from what they regard as the correct approach. An early example of where a court was prepared to follow a divergent approach, which it obviously did not agree with, was a decision of the Patents Court consisting of Mr. Justice Whitford and Mr. Justice Faulkner, to follow the decision of the Enlarged Board of Appeal of the EPO in ISI. That was John Wyeth and Brothers' application. It was concerned with second medical use. They made clear they didn't agree with ISI's interpretation of the EPC, but the matter had to be considered by reference to the position as it had developed under the EPC, and that involved having regard to the jurisprudence of the Enlarged Board, including in particular its decision in ISI. The approach was a possible, even if not the better, as they said, interpretation of the section of the UK statute, and was therefore to be preferred. Not all courts have adopted this self-denying ordinance. It becomes particularly difficult in this country when an issue of principle has been decided by a higher court. In the Court of Appeal, the scope for departing from decisions at the same level is very limited, although it has been held that an exception exists where a previous decision was inconsistent with settled jurisprudence of the EPO. A clear example of this came in relation to the law on excluded subject matter. The 1977 Act contained a rule that a patent could not be granted for an invention which consisted of a program for a computer as such. Here was an opportunity for the EPO boards to provide clear guidance on when an invention was a computer program as such. In a 1984 case, they said, decisive is the question of what technical contribution the invention, as defined in the claims, when considered as a whole, makes to the known art. This guidance gave rise to a number of decisions in the courts of this country, including at Court of Appeal level, Merrill Lynch's application in 1989. These decisions considered the technical contribution made by the claims as compared with the known art, and asked whether that contribution consisted entirely of excluded subject matter, doing exactly, one might think, what the EPO boards of appeal had decided should be done. If the matter had stopped there, all would have been well. But later, in pensions benefit, the EPO moved away from the technical contribution approach, saying that there was no basis in the EPC for distinguishing between new features of an invention and features of the invention which are known from the prior art when examining whether the invention fell foul of the exclusion. The board went on to hold that a claim to an entirely conventional computer running a computer program was not caught by the exclusion. Thereby, it might be thought, robbing the exclusion of any practical effect. The Court of Appeal in this country considered and rejected pensions benefit in Aerotel and Telco. It stuck to the technical contribution approach. It characterized the EPO approach as any hardware will do. The ping pong continued. In Dunn's Licensing Associates, the Board of Appeal of the EPO criticised its own technical contribution approach, and therefore this country's approach as not consistent with a good faith interpretation of the EPC. A more recent example is that of the correct approach to plausibility. Must a patent application provide evidence that the invention plausibly solves the problem in every case, so-called ab initio plausibility, or does the obligation only arise where there are legitimate reasons to doubt that the invention solves the problem, so-called ab initio implausibility? This thorny question came before the enlarged Board of Appeal of the European Patent Office in case G221. Instead of saying it was one or the other, they opted for their own test, which they said was consistent with all the cases that had been decided. The national courts have been given the task of deciding what this means. In the Court of Appeal in England, the court opined through Lord Justice Arnold that the EPO's new test was much closer to the ab initio plausibility test. In Spain, another EPC country, the Supreme Court has said that decision G221 is more consistent with ab initio implausibility. So the EPO's attempt at clarification has produced diametrically opposed interpretations. With the failure of the CPC, the European patent system created by the EPC therefore lacked any court system in which a unitary patent could be enforced. The astonishing thing is that this failure did not kill off the enthusiasm to pursue the goals which had driven the Strasbourg Convention and the CPC. This is what I describe as the second watershed moment. Our legislators could have said that the problems, particularly the language problems, which led the CPC to fail, would beset any similar system which was proposed. Nevertheless, work began towards an agreement for a unified patents court. The story of how the unified patents court came to exist and the trials and tribulations which it encountered are well known. That it did come to fruition is largely due to the efforts of one person, a force of nature, Margot Fröhlinger, who found her way around every obstacle that was thrown in the path of this convention. Judges still speak of the occasion when, by sheer force of personality and oratory, she turned a room of judges hostile to the idea to one that supported it. Of the various objections to the UPCA, I want to mention only one. While there was support for an expert court to decide patent matters for all member states, there was concern that the advantages of that would be lost if there was too great a role for the CJEU, which has no particular expertise in patents. In fact, whilst the UPC must uphold and observe EU law where it applies, the scope of application of EU law in the field of patents is very limited. This contrasts with trademarks, for example, where there is overall Europeanization. The substantive law of patents would not be subject to the supervision of the ECJ. Unlike its position under the Community Patent Convention, the role of the ECJ and the UPC is likely to be very limited indeed. All looked set fair then at this point for the achievement of the ultimate goal of harmonisation, a single court deciding issues of infringement and validity for all member states. Various people got involved at this stage. A group was formed to draft rules of procedure. And premises were required for the London branch, which was to deal with the coveted pharmaceuticals workload of the court. But then the storm clouds started to gather. On the 23rd of June 2016, the United Kingdom voted to leave the European Union. On the 17th of January 2017, the Prime Minister of the day, Theresa May, made a speech at Lancaster House in which she set out her objectives for implementing the result of the referendum. One was to bring an end to the jurisdiction of the European Court of Justice in Britain. Notwithstanding the leave vote and that speech, the UK went ahead with preparations for ratification of the UPC. The obvious inference is that it considered that the minimal involvement of the ECJ was outweighed by the advantages of being part of a court which would bring with it real advantages for industry. So on 12th of December 2017, the House of Lords approved the Unified Patents Court Immunities and Privileges Order 2017, and on 23rd of April 2018, the United Kingdom ratified the Unified Patents Court Agreement. On 20th of July 2020, however, the United Kingdom withdrew its ratification of the UPCA because continuing to participate in the court would be inconsistent with the UK's desire to become an independent, self-governing nation. Given the peripheral involvement of the ECJ in the operation of the Unified Patent Court and the heroic efforts made to reduce its impact on the court, this might be thought to be a somewhat melodramatic characterization of continued participation. After the decades of persistent work which it had taken to arrive at this point, it is perhaps sad to see it being thrown away without so much the nod to those who had worked so hard over the decades to achieve it, or to any of the advantages for British inventors and industry which it would have brought with it. As to acting as an impediment to our desire to become an independent sovereign nation, it's not without significance that the agreement on the withdrawal of the United Kingdom of Great Britain and Northern Ireland from the European Union and the European Atomic Energy Community, which gave effect to Brexit, itself provides a dispute resolution procedure which involves the possibility of a reference to the CJEU on issues of interpretation of EU law. I've not so far heard it suggested that this provision undermines the decision to leave the EU or our ability to become, some would say remain, an independent sovereign nation. Where does that leave the harmonisation project? We still have the European Patent Convention, because it's not an EU convention, and we still have a statute that was expressly drafted on the basis that it was to give effect to the convention and the Community Patent Convention. So all is not lost, and we'll continue to have regard to the decisions of the EPO and no doubt the UPC as persuasive authority. But we will lack the final piece of the jigsaw, which is a single court with jurisdiction for all member states applying a unified law on a unitary patent. We will not be travelling first class. Maybe one day it will be different. That's where we are now and how we got here. Thank you very much.
Thank you very much, Chris. He's told you the story thus far. We remain signatory to the Unified Patent Convention, the Unitary Patent Convention, and we have withdrawn our ratification. There is a strong school of thought that all you have to do is to re-sign. That may be the next chapter and is a live topic. Let us hope so. Chris, thank you for the hell of amount of work you did there, none of which is paid, except in drinks outside. And it's not fair for him to take questions now, except with the drinks outside, which I understand he's very willing to do. So, another round of applause for Chris, and a huge thank you.